Some companies are blatantly playing on your fear, just like the story set out in this post here, which I'll come to in a moment. But before we get to that, this video cannot be taken as legal advice, either by this poster or by anyone else in that situation, because there would be lots of questions I would need to ask, I would need to see the papers and so on. So with the caveat out of the way, let's get into the story. So Patrick here received a private parking ticket, sometimes referred to as a private parking fine or parking fine of some description. Now, it's not a fine because unless it's issued by a local authority, in which case it will be a fixed penalty notice, then it's a private invoice by a private company and they cannot do anything with it unless they have a judgment from a court, which will become important for this story. By the way, if you do have stories like this, do send them to me and I'll go through them, give you my thoughts, and I'll let you know what I think about them as we go through. This one says here, 5 years ago, I received a private parking ticket for parking on a disabled spot at McDonald's. Now, pausing for thought, as I'll do as we go through these sort of things, the first thing I think of is 5 years ago. So we're coming up on limitation, which is 6 years for simple contractual breaches or alleged contractual breaches. Now, if there is a debt alleged to arise from a breach of contract, which is what it would be by a private company if they are managing the car park, there are terms for that contract to park on the car park. For example, the signs have got to be clear and they've got to be clear terms set out in those signs to say you must park here, here, or here. And it would be reasonable for anyone to infer that if someone on that premises that runs that premises, such as the worker in McDonald's, which we'll come to in a moment, if they tell you where to park and that you're allowed to park there, that should be perfectly fine. Notwithstanding, in my view, that it would be managed by this other company who wouldn't have an agent on the premises. But anyway, it is a 6-year limitation period. So if it runs to 6 years, they cannot then bring a claim for it anyway, because it'll be statute barred. Moving on. They were given a private parking ticket for parking on a disabled spot at McDonald's. They went back to see the manager, complaining that they were asked to park there by the server to wait for their food. Now, two things arise there. First of all, the conversation with the manager. So I would always recommend that you make a note of any conversation, you date it and timestamp it, so that you've got a contemporaneous record of what was said by whom, when, and where. So if ever you do rely on that in court later on, you can say, I can be sure of what was said because I made a note of it at the time. It was a contemporaneous note. This is why police have pocket notebooks. They write down conversations. If they really want to prove something was true, they get someone to sign it as a statement by them in their pocket notebook. You can carry around a pocket notebook if you like. You can record it on your iPhone. You can do anything like that you like. I would just recommend that you have a contemporaneous note of what was said, by whom, when, and where. So you can refer to that later in court if you need to. The initial parking ticket was less than £100, usually 50, 70, £80, something like that, which is fine if it is legitimately issued. Now they say, I'm getting countless letters from a company demanding I pay £2,800 or face having my personal goods removed. That is not possible without a court judgment. And I would say that any letter that threatens that is going beyond what is reasonable, and threatening that on numerous occasions, unless it's very carefully worded and says only if we get a court judgment first. But I very much doubt that it says that. Maybe it does, maybe it doesn't. But as I say, I haven't seen it. That's why this can't be legal advice. With these letters, there is a header, as seen on TV. And then goes on to talk about the company. £3,000 could be devastating for many people, especially if they're vulnerable. Interestingly, they are now claiming that it's a business debt. Well, if they claim that it's a business debt, they will have to prove that you're acting in the course of business. And by the way, just because you might be driving a van and you're on your own time and you've gone for some food, that's you in your own time. That's not you on business time. It's only if you're within business time for business purposes, you're acting for business purposes. And any company that seeks to prove that you are acting in the course of business needs to prove that. Very often we get letters from solicitors to say, if your client wants to say they're a consumer, they must prove it, which is wrong. The consumer doesn't have to prove they're a consumer. It's the other way around. The burden is on the company to prove that you're acting in the course of business and not as a consumer. Importantly then, Patrick goes on to say the manager apologised and said he would sort it out. That was back in 2018. So if this ever did go to court, Patrick could just explain all of this to the judge and say, this is what happened. They gave me permission to park there. I took that as read, that I had permission from them to park there, notwithstanding that they might not have been managing the car park, and that was perfectly fine. Unfortunately, Patrick doesn't have this in writing. Who does? Who has a verbal agreement from a manager to say, yes, no problem, I'll sort it out? Who gets that in writing? I suspect even if Patrick asked the manager to put it in writing, the manager probably wouldn't have done so, because the manager would have probably thought, well, I'm not doing that in case I get into trouble with, my boss or anyone that manages the restaurant. So I don't think the manager would have put that in writing in any event. But that's not to say it didn't happen, and Patrick will just have to put this in a witness statement if this ever goes to court, which it would have to do so within 6 years of the alleged breach. Otherwise, it's statute barred. So, as I say, some of these companies do play on fear. This is not to say categorically that the company mentioned, which I haven't named, but it's within this post. It's not to say that they are playing on fear. It's not to say that they are categorically doing that, because I haven't seen the letters. I do know that some companies do that, because I have seen some letters from some companies that make those threats and demands. Menaces, we might call them, because if it's a demand and some sort of threat that is unlawful, i.e. telling you that they will remove your goods if you don't pay, is not correct, because they can't do that without both a judgment from the court and either a writ or a warrant of control to come and remove your goods. And even then, there's certain restrictions. So it is not as clear cut as just write to you and tell you that they're going to come and get your goods if you don't pay the debt. That is not how it works. There are mechanisms to enforce a debt, but only once you've got the judgment. And so unless they do that, this is not going anywhere. And I suspect that if Patrick puts his case exactly as we've just outlined it in this video here, that this claim, if this claim ever did go to court, that it would be either successfully defended, if not struck out beforehand, because it's a very simple explanation and the court doesn't want to waste time on such things. That is my view overall. As I say, it cannot be taken as legal advice by Patrick or anyone else, but it's what I think on these situations. Now, speaking more generally, people do often ask how to challenge these things. What I don't recommend is ignoring them. I get lots of comments. Even when I had one myself last year, I had a private parking ticket, which I challenged with a very polite letter to set out, because I did have a permit to park where I was parked. They just didn't see it. So they put a parking charge notice on my vehicle. I wrote a very polite, albeit fairly stern letter outlining the law and why I should not be liable to this parking charge notice. And they came back perfectly reasonably and just agreed to suspend the ticket. They didn't admit any liability in that letter. I don't expect them to. But if you are polite about these things and you write back and explain the situation, they sometimes will take that into account. Sometimes not. I hear many stories of where they won't do that. But one thing I can tell you is that burying your head never looks good. So if you bury your head and you ignore these things, especially if they've filed a claim in court, it will always get worse. I've just this morning released a fairly lengthy podcast talking about navigating the civil litigation system and how to avoid certain pitfalls there. Broadly similar to what I'm talking about now, but this is specifically in relation to parking charge notices. But I hope you found that useful. Send me your stories to talk about. And as always, thank you for watching.